Okay, welcome everyone. We are so glad you're here. You are here for a webinar presentation called Towards Child-Centered Justice as a System-Level Paradigm Shift. It is being brought to you by a collection of organizations led by the Children and Young People Center for Justice. We're very glad you're all here and thank you for joining us. My name is Angela Vigil and I have the great pleasure of not only being a lawyer for children for my entire career, but also helping lead up pro bono at the law firm of Baker McKenzie. And I'm very proud that at Baker McKenzie, we do work with so many of the organizations, leaders, and lights of the children's world who are here today to be speakers in today's session. We are going to have a collection of a lot of people speaking over the next 90 minutes. So we encourage you to participate in the conversation by putting questions into the chat as we go, and we will do our best to address those as we're speaking. And then towards the end, we will have one of our leaders really sum up and do our best to get to all of your questions through the day. So rather than raising your hand to participate in the discussion, we do encourage you to type in questions. Our topic today, child-centered justice, is really this idea of having systems that are designed for children and young people, and not just a system that might have been designed or not for other types of folks, and then trying to refit that for young people. Anyone who's tried to put on an extra large adult shirt on a toddler knows that while you can make it work, it doesn't make the child thrive. And that's what child justice systems are supposed to do. So we'll be particularly drawing on Scotland's whole system approach as a practice-informed case study as we talk about how child justice principles can work for policing, for prosecution, for defending, for care and custody. Lots to learn. We're going to do that first by hearing from two speakers. First, Cédric Foussard, who's the founder and president of the International Center for Justice Alliance, a nonprofit international association dedicated to advancing people-centered justice, inclusive and effective justice systems worldwide through collaboration and innovation and strategic dialogue. We'll hear from Cédric, and then we will hear from our own Professor Fiona Dyer, who is the director of CYCJ, and towards its ambition of ensuring that Scotland's approach to children and young people in conflict with the law is rights respecting and contributing to better outcomes for children, young people, and communities. Following those two interventions, we're going to have a short panel discussion between Nicole Drew, a policy analyst in the OECD Public Governance Directorate, where she leads work on youth empowerment and intergenerational justice across OECD, and Zara Gasparian, who's a child rights expert at the Council of Europe, where she heads up the Cooperation and Capacity Building Unit in the Children's Rights Division. And then finally, we will end our day today with a wonderful summary by our own Professor Jennifer Davidson, who's the executive director of the award-winning Institute for Inspiring Children's Futures at the University of Strathclyde in Scotland. Lots more to hear about our outstanding speakers, and we'll be putting their bios into the chat as we go. But we want to get started right away. There's a lot to talk about, not just how child-centered justice should work, but really starting the discussion with how it's defined and what that means. Because especially for those of you coming in who are not experts and practitioners in children's work, you would assume that children's systems have always been child-centered. And unfortunately, it really is a new paradigm-shifting development. To give us a discussion about that definition and where that's going, that conceptual framework, I will turn it over to Cédric Foussard. Welcome, Cédric.
Thank you very much, Angela, and good afternoon, good morning, everyone, and welcome to this webinar. So, as you say, Angela, my presentation today is not only to give some information about this concept on child-centered justice, but I want to make the case that child-centered justice is not an aspiration. It is a systemic obligation, and we already have the tool and the evidence to build it, and we will hear about that later with the other speaker. So I will set the conceptual scene, and then Fiona and our colleague from OECD and Council of Europe will show us what it looks like in reality and when it's fully in function or implemented. Next slide, please. So let me come back a little bit about what we understand by people-centered justice. No, let's start with this broader concept. So we are living through a significant shift at the moment in how the world is thinking about justice. So for decades, justice reform focused on institutions, on courts, on laws, on procedures. But now there is an emerging paradigm which is different. It starts with people, that the concept of people-centered justice. No, it focuses on their needs, on their experience, and of course on their right. So this is what we call people-centered justice, and it's grounded in the Hague Declaration of 2019, advanced by the Pathfinders on Peaceful Justice, Just and Inclusive Societies, the OECD, and the World Justice Project. And he asks a simple but radical question: does justice system actually work for the people who need it? And that is a fundamental question in our field. So the answer, unfortunately, it's often globally no. More than 5 billion people lack meaningful access to justice all over the world, and progress towards the SDG, the Sustainable Development Goal 16, on peaceful, just, and inclusive society, has clearly slowed since COVID-19. So the gap between our ambition and reality of people's lives is really increasing. So people-centered justice is the right response to this, but there is a blind spot for this movement to be truly universal, and that's what I'm going to try to demonstrate, is that it should embrace fully children. So not children as a marginalized group or category, that require a special accommodation, but as a world, 30% of the population, which has the own right and needs. Next slide, please. So why children need a distinctive approach? And that is a full question. Why we don't just apply the people-centered justice framework to children? Because children are not mini adults with mini rights. They treating children as simply younger justice user miss something fundamental, no? And risk reproducing the very inequalities that people-centered justice seeks to address. So there is 3 dimensions I wanted to insist here. The first one is the development. So and you all know here certainly that the child development or the child maturity is evolving, and the child brain is in development. And in particular, we know that the prefrontal cortex, which is the part that of the brain that governing the reasoning, the impulse control, the decision making, continue to be formed until the mid-20s, not even 80s, but 18, but after. So children capacity to understand those proceedings or justice proceeding, to consent to intervention, to navigate through a very complex institutional system and vocabulary is still evolving. And at every stage, they depend on adults in ways that profoundly shape their interaction with justice institutions. The second element is the needs. When we speak about children, we speak about the specific needs they have. They need age-appropriate information. They need a specific environment. They need specific procedures at every stage of the process. They need protection from re-traumatization within the justice system themselves, of course, where we know there is a potential violence or harm against children, and they need those responses to be grounded in rehabilitation or reintegration mechanism, not on punishment. And that the message of the Convention of the Rights of the Child is the focus of the justice system should be the reintegration of the child into the society, not sanction, not punishment. The third is a right, and under the UN Convention on the Rights of the Child, the CRC, children are clearly right holders first. So there is no, they are not object of protection or correction, but they are right holders and should be respected this way. So you see, it is to really create a child-centered justice, we could not just have a subset of people-centered justice. We need its full expression. Next slide, please. So what do we mean? What is that, this child-centered justice concept, right? So in June last year, 1 year ago, we had in Madrid the 5th World Congress on Justice with Children, which gathered more than 1,000 participants in Madrid and around 6,000 participants all over the world. And in the context of this Congress, it was adopted the Global Declaration on Advancing Child-Centered Justice. And it defined, and I quote here, and you have the text on the slide, it defined the child-centered justice as a system-level approach, so at systemic level, to justice in which children, their rights, and their lived experience constitute the central reference point for the design, the functioning, and the evaluation of the justice system. And later on, based on the result of the World Congress, we published an article with Fiona and Jennifer in the Youth Justice Journal, where we built on that definition and precise that child-centered justice is a right-based, solution-oriented approach. And I pretty like this concept of solution-oriented. We are trying to figure out what can help the child to reintegrate the society. So it's systemic, normally procedural, and emphasizing the effective participation and the empowerment of the child. So you see those elements are based on 4 dimensions that make this definition significant. No, it's the core principle of child-centered justice. So first, they base on the Global Declaration. First, children are right holders, as we say, which bring an important element that states are accountable for the right compliance and across all the stage of decision making. Secondly, the best interest of the child is a primary decision. And that is supported by actually the Article 3 of the UNCRC. The third is a meaningful participation. I will come back to that after, but it's linked to the age and to safe environment and to the support of adults around. The fourth is a developmental response, and I think that is very important to remind everyone that offending among children is episodic, transitional, and opportunistic. It is not permanent. So system must not make what is transitional into something irreversible. And the fifth is a protection from harm within the justice system, and that the element which was actually at the heart of the World Congress last year, where we tried to figure out the issue of violence against children in justice system. So I wanted to then to come back to that element of child participation. No? There is several, no, it was good. We go on child participation. Thank you. So we words matters, and we speak about child participation, but there is a lot of vocabulary around and wording used by different academia, research, etc. So I wanted to make the point a little bit of what we mean. And there is several levels on the child participation elements. There is first 3 general contexts, right? Applying to all the sectors, not only justice. This is the child-sensitive sets of minimum the child-sensitive aspect. So that the minimum normative floor, that's the basic. It's legally binding, it's an obligation, and it's under international law. Then you have the child inclusiveness, and that go further. It's about the concept of equity, of non-discrimination, and the idea that we use in our world of leaving no one or leaving no child behind. And then the last one is the child-led aspect. And child-led is where children initiate, they directly act. No, they are agent of the program, of the situation. But then we have two elements about what we understand on child participation in the justice system. The first one is a well-known child-friendly justice system that was led by, in particular, the Council of Europe, and did a fantastic work to push for a better a service adapted to children, a better procedure specifically designed for children with the right language, right environment, trained professional, etc. And then you have the child-centered system, which operate at a different level, which is more systemic level. It's a question of governance and design of the whole system. And that is illustrated by the Lundy model that you certainly know all. So on this aspect, we have three domains of action that translate this child-centered justice into practice. No? Those elements that we saw before about child participation, etc. The first one is around the pillar of prevention and diversion that address the roots causes before children enter the formal justice system. And you got a lot of interesting program around that, and we'll perhaps have time to speak about that. But one of those is in the Netherlands, the HALT program that work on really the first contact with the justice and with the police. The second one is the pillar that enable environments. So giving safety, child-centered physical space and procedures, making that the child is at the center of all those systems. This is clearly the Barnabas system, and we will certainly hear about that from our colleagues later on. And the third one is a systemic reform. And the systemic reform is bringing the meaningful participation of children, not just in the proceeding, but in the plural legal system. So all of those are focusing on child participation and the element of developmental and age-appropriate response. The next one. So you will ask me perhaps how we make that concrete. What does it mean in terms of project, no? Ground to down to earth, no? So there is an interesting study that has been published by our colleague from the Institute of Inspiring Children Futures on the game changer for child-centered justice. And the concept is studying the different practices from all over the world and research. We managed to identify what are the game changer to make sure that a justice system basically is really child-centered. We will certainly come back to that later, but you see it brings concept of making sure that there is collaborative alliance, which we call as well a multidisciplinary context and setting. It's bring as well the effort on prevention of harms, prevention of criminality. It brings as well concept around systemic inclusion efforts. So all of those bring the different level of programs that are important to implement the child-centered approach, and that are perfectly some way presented and defined in the whole system approach that Fiona will speak about. The last one. So, you know, I just wanted to finish with that about this conceptual framework, and you remember perhaps we will this work has been based on an article that was published a few months ago that we put the link on the chat. But the concept is there. Child-centered justice is not an ideal. We already have a lot of tools. We have obligation. We have legal framework. And of course, we have evidence that show it works. Thank you.
Thank you, Cedric. And just so everyone knows, we are recording this, and for everyone who is registered, you'll not only receive the slides but also the recording afterwards, because I know we're going through a lot rather quickly. But it's important to do that because there is so much to discuss. And we'll continue this discussion about what Cedric was talking about in this idea of this being not only multidisciplinary in that we have to focus on child development, multiple sectors in that we have to focus on children's needs, and that an issue of state obligations through rights. And no one better to do that than our own Professor Fiona Dyer, who, after starting a career as a social worker in this space, has become the director of CYCJ and is really going to talk about this multidisciplinary approach where she leads so much of not only experts, but also practice in very practical ways. In the example that we will talk about from Scotland, let me invite you in to discuss, Fiona.
Thank you, Angela. It's a pleasure to be here today. So as you've heard Cedric talking and really looking at what is child-centred justice, and we've just got this slide here because I think we are moving on from the child-friendly justice and taking it a step further to the child-centred justice. And when Cedric and I have been talking over the years, I suppose I have been sitting saying, yeah, but we're doing that in Scotland, Cedric, we are doing that. So hopefully I'm going to demonstrate how we are doing that in Scotland today. There is always room for improvement, but I think we're definitely on a journey in Scotland to be truly being child-centred for children and young people in conflict with the law. I'm going to cover a lot, as Angela said, so I'm obviously happily, as Cedric is, to take questions later on, and we will share our slides. So just a wee bit about Scotland, some of the images. People who are not from Scotland might associate with Scotland. We are very proud in Scotland to be Scottish, and in 1999 we had a devolved government in Scotland. So this means Scotland has its own parliament and it can make its own decisions on domestic issues, and boy do we like making decisions. We have loads of policy and loads of legislation, so much so our legislation sometimes is not implemented or is not not implemented in a timely fashion because we've got so much and we're all trying to keep up, but we are very proud of our Scottish roots and what we've achieved. Now, this is some of the foundations in Scotland. It's not all of them, but it's some of the foundations that govern our policies in relation to children and young people in conflict with the law. I don't have time to go into a lot of detail but for them all, but I think it's really important when Cedric was talking about the pillars to really look at how the system reform and how it's reformed over the years. I'm going to talk about a whole system approach that was introduced in 2011, but we've not sat on our laurels. We have been changing and adapting and developing that policy across those years as we have our legislation and general policy. Some significance that have changed, obviously our age of criminal responsibility, embarrassingly low at 8, was raised to 12, and we're still in discussions and hopefully looking at raising that further. We did raise our age of prosecution back, I think, in 2015 to 12, and there aren't many children in Scotland who go through our criminal courts. But those that do, we've got sentencing guidelines and our Lord Advocate's guidelines, where the presumption is that children go to our children's hearing system, our child justice system, and not go to adult court. But there's also sentencing guidelines if children are at court, that their age and stage of development is taken into account. We've also got getting it right for every child, GIRFEC, as we call it in Scotland, that really puts children at the heart of all decision making and is the basis for the whole system approach. We've had guidelines and standards co-produced by children and young people. True example of participation where services are now follow those guidelines and are inspected in relation to those standards that were set by children and young people. But I'm going to touch on some of these. So those of us that are not from Scotland, just Scotland is governed by the Children's Hearing System. Now this came into effect in 1971 in Scotland, and this was to keep children out of criminal courts. And the basis of this is that children should be seen for their needs and not their deeds, purely taking a child-centred approach. So children go to the Children's Hearing System on offence grounds or on welfare grounds, and this is because in many occasions they are the same children, or the children are there with the same needs, and its decisions are then made in relation to these children. Now, children can go to the Children's Hearing System currently up to age 16, or they can remain in the hearing system up to age 18 if they're referred before 16, although we have got legislation currently that has passed Parliament that will change that in the future. We also, although we signed up to the UNCRC, the United Nations Convention on the Rights of the Child in 1991, it became legislation in Scotland in 2024. So now we have that in our legislation. We are ensuring all previous legislation upholds the UNCRC, and all our policy decisions are in line with the UNCRC. And again, some of the articles there are specifically to children and young people in conflict with the law. And relevance there as well to General Comment 12 and General Comment 24, which again give further information that help us govern us and help us stick to the UNCRC. A massive piece of legislation for Scotland was the Children's Care and Justice Act in 2024. Now, this truly recognises that all children up to 18 are children. And it removed all our children under 18 from our young offenders, so from our prisons. And it also has increased the powers within the children's hearing system. So all children on welfare or care, welfare or offence grounds will, once that's enacted, be able to go to the children's hearing system, so that they will not need to go to court if they have been involved in criminal behaviour. We also, within that, have improved safeguards for children in police custody, and we've enhanced our information for children who are victims. So that act, some parts have been enacted in August 2024. The children who were still in our young offenders were removed into our secure care houses. Now, when whole systems came into effect, our number of children in our young offenders who were 16 and 17, there was about 120. When we removed the children in August 2024, there were 5 children were removed, 5 boys. There were no girls in custody that whole year. So this is part of our policy and legislative journey. So we had our Kilbrandon, our children's hearing, we've got GIRFEC, we introduced the whole system approach, and then from that we had real significant pieces. We had our age of criminal responsibility in 2019, and it came into force on the 21st of December 21. We had our independent care review reported, which became the promise, which spoke to thousands of children and young people who had experienced care to make improvements and changes. We had the UNCRC into legislation and the Children's Care and Justice Act. But we've not stopped there, because we've also got our other legislation that is currently went through Parliament and just passed, that I'll touch on later. So the whole system approach was introduced in 2011. Now, the basis of the whole system approach, you'll hopefully be pleased to hear, it was evidence-based, and this was based on the Edinburgh study of youth transitions and crime, and Les McCarran and Susan McVie led on that study, and they reported in 2010. Now, they had 4 main sort of points from their study. There was lots of information there, and they have followed up. It was a longitudinal study. It's looked at over 4,000 children and has followed them through time. But their evidence firstly found that persistent engagement in serious offending was forms of the young people involved in that had various forms of victimisation, vulnerability and social adversity. They were some of our most traumatised children and young people. They secondly found that early identification, so actually bringing children into the justice system too early, actually kept them in the justice system, and it was more detrimental for them. It had a more negative longer term outcome. Thirdly, what the teenage years and the response to children at the teenage years, as Cedric said, you know, this behaviour can be stopped in the involving in development. So how we responded to children and young people is really important, and looking at more prevention and early intervention was more effective. And finally, they found that there was children were labelled, and especially children from our most deprived areas were labelled, and we really had to look at the interventions that were provided to that group of children and young people. So that was the basis of the whole system approach. And these are the elements that made up of this whole system approach, which have developed and progressed over the past 15 or so years. So we had early and effective intervention. Now, the key points for this was This was a pre-bringing children into the justice system. This looked at how we could respond to children in a multi-agency way if that was appropriate. There was early intervention coordinators across the whole of Scotland, all 32 local authorities that made an assessment. Now that could be for no further action, it could be to take the needs of the young person, discuss in a group and decide the best way to respond to that young person. And this was to stop young people coming unnecessarily into the children's hearing system. And at the time, that reduced referrals to SCRA, that oversaw our children's hearing system, by 79%. It meant that the children and young people who were referred to the system were the ones who had the most sort of detailed, complex needs that needed a more formal response. The rest of the children and young people, we could divert them through early and effective intervention. For the children and young people who couldn't be referred to the children's hearing system due to their age or because of the level of their offending, there was diversion from prosecution. Now, this wasn't just for children, this is available, but this was as part of the whole system approach specifically for 16 and 17-year-olds or those under who were referred to our prosecution service, that we would divert them so they would not need to go to court. And again, that was extremely successful in reducing significant numbers of children and young people going through our court system. As part of that, the Lord Advocate's guidelines also changed so that children, the presumption was that when the Procurator Fiscal or the Children's Reporter were discussing who should maybe deal with a child, if they were open already to the children's hearing, that the presumption would be that they'd go to the children's hearing system. If children did have to go to court, we'd follow this, that they, as we've heard Angela and Cedric saying, there are not many adults, they need support. Children do not understand the court process, they cannot meaningfully participate in our Scottish courts. So we wanted to make sure that that was taken into account if they had to go to court. We also promoted that the court who could remit the child to the children's hearing system did that. But what we've done over the years is developed blueprints of how we can support our children and young people in even more detail if they go through court, so they can have a say. We have supported them to really look at, could we have youth courts, and we've developed them in some area, but looking at the language used, the training for our judiciary and court staff, the layout, you know, and so that is there to further support children and young people who maybe because of the severity of their offence or to be within Scottish law, it could be road traffic offences, or they're older co-accused, they may have to go to court. So this is to support children and young people in court. We also, part of the whole system approach was to look at community alternatives wherever possible. Locking children up, depriving them of liberty should truly be a last resort and for the shortest time. So we'd look at keeping children in their communities on some supervision through our children's hearing system, and really looking at bespoke alternatives, including intensive support and monitoring, which did include and does now still an electronic tag, but to keep children at home, but that would include intensive support. It couldn't be done without intensive support. And if a child was deprived of their liberty, either in secure care or our young offenders institution at the time, that they would be supported to reintegrate, that we would be met at the gate, that there would be regular meetings. We introduced reviews within 72 hours of a child being taken into secure care or custody. That was a 72-hour review to plan for their release. And that was all seen under our framework for risk assessment, management, evaluation, with a specific aspect for care and risk management to how we manage the risk. And this was important to make sure care was part of that. It wasn't about just risk management, it was looking at children being different. How did we manage the risk, but also look at their development and provide that for them. So those components all came under the policy of a whole system approach. Over the past about 8 years, maybe, we have been looking at how we can extend the whole system approach, advance the whole system approach, really looking how we can extend that to children 18 to 21-year-olds or 26 if needed and being care experience. How can we increase the use of diversion? How can we increase more children going through EEI and extending EEI for 18 to 21-year-olds? So that work is still ongoing. And we've got different groups currently that's under our Youth Justice Improvement Board working on that. And one of the significant changes that's happened just before our parliamentary recess for the election was that we passed legislation that now changes legislation that children do not need to go to police custody to be interviewed. They had to, prior to this, the Children's Care Experience Bill got through, so that's now will become an act. And when that's enacted, then children can be taken to more trauma-informed environments, like the Barna House that in Scotland we call the Bairns House, Cedric, or a social work office, or a different, more trauma-informed environment that they could be interviewed instead of being in police custody. So that brings us to how, when we've had discussions, I feel Scotland is on the journey to really truly being child-centred with children and young people in conflict with the law. We're really looking at the pillars that Cedric mentioned, looking at prevention and diversion through our work, looking at the enabling environments that we are really working hard to get better, to be trauma-informed. And one part of that is our reimagining secure care that we have currently looking at, even how can we improve secure care? How can we look at more trauma-informed environments in local communities? That's something CYCJ was commissioned to do, and the government have consulted on that. And we're hoping we'll have the analysis of that consultation in the next few weeks to really look at how Scotland can be even better for our children, young people who are deprived of their liberty. But also that the system reform and our legislation and our policy has changed over the years to truly be on the journey to being rights respecting and child-centred in Scotland. So that was a very quick run through, but thank you for listening.
We so appreciate it, Fiona. Thank you so much. Yes, lots of information, but a wonderful way to give a very practical example out of Scotland of what systems are aiming to do and trying to do, and Scotland is really achieving. I'd like to invite us to move on to a little bit more of a panel discussion now. We won't have slides. I believe we will just have a conversation where I'm going to pose some questions to two of our speakers. Who are joining us from intergovernmental organizations. And so we're going to have a couple of questions for both Nicole Drew, who I'm bringing on, from a policy analyst in the OECD Public Governance Directorate. She leads up work on youth empowerment and intergenerational justice across OECD. So policy analysis, especially in the area of the Middle East and North Africa, but focusing on strengthening institutions and the rule of law and regional cooperation. Also bringing into this conversation with me, Zara Gasparian, who I introduced earlier from the Council of Europe, who heads Cooperation and Capacity Building Unit in the Children's Rights Division. Both of you all have some perspectives that are both zooming in on very practical explanations of what it is that different countries can do and what's possible, and zooming out to think about sort of what's in place procedurally. So I'm going to ask if we can take down the slide and just have my two speakers on. And I think we've had a little bit of trouble with the camera for Nicole. So Nicole, I want to make sure you can hear me and you're able to speak.
Hi, Angela. Yes, my apologies, everyone. I have my audio functioning, but I don't think my camera is enabled. So apologies.
Got it. No worries. No worries. No worries. And then Zara, you can hear me as well, so we can get started.
Yes, everything is working well. Thank you.
Wonderful, wonderful. All right, so let me start with Nicole, with you, because we want to talk about the OECD's child-friendly justice framework that was developed and introduced in 2023 that provides guidance against a different set of pillars than Cedric was discussing earlier about designing and delivering what is called child-friendly services at the time, establishing governance enablers, empowering children and practitioners, and then planning and monitoring and accountability, the kinds of big picture system questions we ask for. And I wonder if you can help us all understand how that framework might help all countries, as we zoom out from Scotland, move from good intentions to actual system level change, and what common gaps are that you've observed in those OECD member countries with this framework.
Sure. Thanks so much, Angela. I think everyone agrees that children should be treated differently by justice systems. The hard part isn't in the principle, but it's turning it into something that a system actually does every day, day after day, long after the launch event is over. And that's the contribution or the intention of the OECD framework. It's taking child-friendly justice and turning it into an operating model, a blueprint, as Fiona was mentioning, a way of running the government. And it's premised on the core understanding that child-friendly justice is not just one public service. It's a whole suite of government services organised across the government, including the governance arrangements to sustain them, the people trained to deliver them, and the data to prove that they're working. And that's what the OECD's framework tries to do. It advocates for the connection of the core elements to drive systems change. This includes the system design, the governance enablers and the infrastructure, the empowerment and inclusion of children and frontline workers, and of course the planning and accountability mechanisms that let us know things are working or if they're not and need to be corrected. And I think what you've just heard from Fiona and the Scottish example is exactly that in action. The whole system approach isn't a single program. It's early intervention, diversion, court support, community alternatives, and reintegration, all wired together, underpinned by the Children's Hearing System and now the Children Care and Justice Act. And that's a system, not a single service. The Bandhuis, Scotland's Bandhuis, is a primary example. One house, one interview, and the child tells their story once. But the honest lesson across the OECD membership, and we're quite a diverse group from the Americas to Europe to Asia to my home in Australia, is that what turns a pilot into lasting change is the unglamorous machinery behind it. Who coordinates it? Who's accountable? Who pays? And how you know whether children are actually better off. On implementation gaps that you mentioned, there's actually a really useful report out of Australia. I can pop the link into the chat, and it's called Help Way Earlier, and it's from the Australian National Children's Commissioner. And the core finding from that report is quite striking. We already know what works. Early help before things hit crisis, diversion away from the formal system, and dealing with the real drivers, housing, health, education, and not just the offence in front of you. So governments knowing what to do isn't the problem. In essence, I think we all already know what to do. The problem is in implementation. Governments keep failing to actually do it. And in my opinion, I think that's a governance failure, not a knowledge failure or a justice failure. In Australia, for example, child justice falls between federal and state budgets. No single level own it. The national government runs health and schools. The states run courts, detention, and child protection. So when the levers sit in different hands, coordination is genuinely hard. And putting the child at the centre means making all of those parts behave like one system instead of each defending its own patch. The same report from Australia also lands the poverty point really powerfully. In Australia, a child from one of the poorest areas is around 7 times more likely to end up in youth justice supervision. So again, we're not talking about a justice gap. It's unmet service needs across the whole of government, health, education, housing, arriving at the justice system's front door. So in Australia, the report and the fix they're proposing in recognition of these coordination challenges is structural change, a national coordinated approach, a cross-sectoral ministerial council for children, legitimately putting children at the centre of policy design, not just looking at youth justice processes in isolation. So to conclude, to round out my response to your question, Angela, I think that getting this wrong has a price you can really measure. In Australia, around 70% of children are back in detention within 6 months of release and 84% within a year. So that's not a deterrent, that's a system paying again and again for the same failure.
Absolutely. And I'm going to come back to you to ask about this idea of, okay, but how do we pay for this? And how is it very practically, how are pitches made to governments about how to do that? But I want to bring Zara into the conversation to talk a little bit more about challenges first. Zara, sort of focusing on in your arena on Council of Europe's framework for child-friendly justice, you see challenges, and we want to ask you about challenges and then successful efforts to ensure effective alignment with this framework, and give us your thoughts on that.
Thank you, Angela. And actually, thank you, Nicole, also to have this conversation around the funding, because I think that is a very interesting conversation we will have just in a little bit. But yeah, going back to the Council of Europe, as you mentioned rightly, it's an intergovernmental organization. So we have 46 member states, and child-friendly justice guidelines have been adopted in 2010 by all these 46 member states, which means that, there is a lot of discussion, a lot of negotiation on any adopted text. And I think just the fact, I also want to refer to what Cedric said, that we're moving, or what Fiona actually said, that we're moving from child-friendly to child-centered. By it itself, this is a challenge, because of course in many of our member states, we see a reluctance to this move. And the reasons are different. I think the main reason is that this is interfering with the due process in the justice system. So already this little, maybe it's not little actually, but this change already is creating a lot of nervousness in the justice systems of our member states. And I think overall, this comes down to a mindset change. It's not about how we perceive the due process. The due process will be respected even if we move from child-friendly to child-centered. We'll find a way, I'm sure we have brilliant lawyers for that, to find a way to protect the due process. But do we really want to change the way that we have been doing things for all these last years? And this is a discussion also that is currently happening within our member states in the Steering Committee for the Rights of the Child, within the framework of the review process of the child-friendly justice guidelines that have been adopted 16 years ago. And obviously there is some need to look into them and to see if any gaps exist and that new challenges have arisen in these recent years. But also, I would like to sadly mention that very banal and very obvious challenges still exist. Something like the access to justice. As again, Cedric mentioned, 5 million people in the whole world still lack access to justice. And out of these 5 million people, many of them are children. They lack have faced significant barriers in accessing justice and in knowing their rights, having financial obstacles or absence of specialized legal aid. In a lot of cases, children do not automatically get an independent lawyer or advocate for their rights, especially, for example, in civil and administrative matters. We have just concluded a technical assistance project in Slovenia, where just 3 years ago, it was not an automatic thing to have a guardian ad litem for children going through high conflict, separation and divorce cases. And now, because of the project, we have put in place policies and procedures that guarantee this right for children, to name just an example. Another significant issue is the confidentiality and the fact that children often face their offenders, and that media and publicity and data breaches happen in cases where children are involved and the child's best interests are not protected. These are, of course, also rights that are protected by the guidelines of the Council of Europe. However, not always all the journalists know how to report on cases, for example, like that. And that's why we're now preparing in our Lanzarote committee, we're preparing a guide for journalists on ethical reporting for cases involving children, mainly for cases where child sexual exploitation and sexual abuse is involved. However, this will also guide other cases where journalists are reporting on cases involving children. And then finally, of course, I cannot not mention the coordination across sectors. We have spoken already quite a bit about the Barnhu's model or Barnhu's model in Scotland, and I've been following actually the development of it. And congratulations! It's a great. It's great that you're doing it, and I do believe very strongly that. This type of models are the ones that we need to pursue, and we need to pursue not only in criminal proceedings, but also we need to open them up to other administrative or civil proceedings, and also to children that are not that show harmful behavior, and not only victims and witnesses. So I think if we don't have such coordinated systems, this can definitely and this does lead to fragmented approach, very duplicated processes, inconsistent approach, and lack of holistic treatment of children's needs. I think I'm going to stop there, and then, yeah, happy to answer other questions.
Well, thank you, Zara. And I appreciate the concepts of how important this is, thinking about child justice systems from the perspective of the children in them, which of course would have you focus on coordinated systems, thinking about confidentiality so that children who've become involved in justice systems can thrive after their involvement and later in life. But I'm most intrigued and really leading this to a question about child, not just participation, but as Cedric mentioned, child leadership in their own engagement in systems. You talked about due process. And of course, a part of due process that all systems should be embracing is empowerment of the person in the center of that process, which has to do with being a rights-bearing individual, being able to make decisions or at least be heard on the child's perspectives on what should happen to them engaged in a system. That requires coordinated systems, but that is the core of due process, which really leads us to a discussion about child participation. And I wonder if you could help talk about this idea of the strategies that can be used to overcome those barriers in these systems that, as you've talked about, have been doing the same thing for a number of years. Change is a challenge. We sometimes will use the excuse of due process to say that we can't make a change when really it's an unusual mindset change, as you mentioned, to have children leading a discussion about how systems should treat them. So if you could talk a little about your experience and thoughts on what strategies can be used to overcome these barriers to child, not only participation, but leadership.
Yeah, thank you, Angela. Very, very difficult question, I have to say, you're posing. But indeed, I personally think that things change when people believe that this change will be beneficial to someone, to the children, to the system, to the economy, to something. So I think that many countries and many organizations do child participation to some extent, but it's very tokenistic and probably not so meaningful. And honestly, it is very difficult to make it, if you really want to do meaningful child participation, child-led processes, you have to invest a lot of effort, a lot of funds, a lot of mindset change, a lot of social behavioral change. So it is, for me, this is the most difficult thing. And as you said, this is the core of due process, but we need to convince everyone that that is the core of due process. And actually, I think that is the most difficult thing to do. So for me, I'm not reinventing the wheel, to be honest. We just need to raise the awareness of people and try to show them the benefits, try to do something meaningfully, and try to do it with children and not just about children, taking decisions with them, by them, actually, them advising us and not us advising them and taking some ideas from them, and try to show the benefits of it. So recently, for example, and I've been working in the children's rights field for the last 10 years, and recently I've just come across to a child rights impact review. It's a compilation. It's a study on children's opinions on Barnehus model, and it's a desk research study. There are no direct interviews, but it was very interesting. So they have basically analyzed everything that they could find when children were consulted on the services in Barnehus type models. And the study was so revealing for me, for a professional who has been working in the child rights field for a number of years. The first thing that the children say that is important for them is kindness, actually. So I would think it's important for them that they're interviewed in a child-friendly manner, or it's important that the premises are child-friendly. It seems very obvious and banal, but I never thought they're gonna mention kindness. And actually, kindness is the most important. It came like above everything. It's not so important for them to get justice, for example, to get the criminal, get their conviction or something. The kindness of the process was the thing that really got the highest score. So I wonder, if we don't have children leading this process, do we really respond to their needs? Do we really know as adults what their needs are? Do we really know that when we speak to them, they're going to reveal this to us if it's not led by them? So these are just rhetorical questions that I guess we all have answers for ourselves.
Having had the pleasure of working with child-led and now teen and young adult-led organizations in the United States, in my work in child rights, the slogan of "not about us without us" is very much sort of captures that spirit of young people, and to stop looking at systems that they didn't design and then being surprised why they fail them. So I appreciate all those thoughts, and I want to bring that back to your discussion, Nicole. We know change isn't free. And we know that systems need support and mechanisms to do all of the transformation and the innovation in the truest kind of innovation that we're all talking about. But to say that the world is in a space of tight fiscal environments doesn't really begin to capture it. It's hard to sell prevention and diversion and things that are anticipating less involvement in systems. It's easier to sell the need for brick and mortar and sometimes detention and facilities and those kinds of the things that we're trying to move away from. But it's easier to make a pitch to those sometimes when you're talking about leaders and country leaders. So how do we make that investment case for child-centered justice compelling so that ministries and leaderships in government are thinking about it, especially because budget cycles are so short-sighted as well as short timeframes? It's a big question, but how do we get countries to invest?
Thanks, Angela. Yeah, and super timely question, because I think we're all dealing with the same fiscal constraints these days. It's a hard sell, no question. It is a hard sell, particularly at this current moment in time. But let me open with a number, again, from the Help Way Earlier report. It costs around 2,800 Australian dollars, so that's around 1,700 euros, to hold a child in detention for 1 day. That's 1 day to keep a child in detention. So we are already spending, we're just spending it at the most expensive and least effective part of the system. The OECD's approach to justice is people-centered. You start with the person, the child's actual needs, and you let that drive the design. You build the system of coordination around the child, multidisciplinary teams, integrated responses. That's where the magic happens, when the services bend to the child instead of the child being passed between the services. But I do want to be honest about why this is so hard to prove. We tend to measure processes, how many interviews, how many referrals, how quickly the court process was resolved. And sometimes I think that we can lose sight of the things that actually matter, which is the outcome. Did this change the child's life trajectory? The discrete steps themselves are quite easy to count, but how they aggregate and how they add up to a different life is much harder. And that's the real measurement challenge. Even measuring recidivism rates themselves is inherently challenging. There's no single definition. Is it rearrest, reconviction, or return to custody? And the follow-up windows differ, so the numbers aren't comparable across systems. A rise can mean more offending or sometimes simply better detection. But the good news is it's becoming possible. With digitization and with data systems that can finally talk to each other, we can start to follow the child through the entire system rather than counting activity in silos. And yes, Angela, to your point earlier, this also at the same time also raises confidentiality challenges to make sure there's no downstream prejudicial use of information as well. But multilateral institutions are starting to build the tools for the governance around this. The Council of Europe's recent child-friendly justice assessment tool is excellent. It sets out that the process and the outcome indicators side by side, so you don't lose sight of the outcome indicators when you're busy measuring the process. And in my opinion, this is how we build the financial case. Better data builds the evidence builds the business case, and then the business case is what shifts the politics. Once you can show a finance ministry the outcome, fewer children coming back, better lives, costs avoided down the line, you've stopped asking them to spend, but instead you're offering an investment. And I think that's how we begin to ask governments to start looking past single budget cycles and commit to funding that lasts, because the evidence is there to back it.
Absolutely. And I'll add to that that I think that we've seen in some systems in North America, a part of that pitch being think about the strengths of children involved in systems and not just their current circumstances and their current needs. Strength-based advocacy can do wonders. There's some states in the US, for example, that are actually budgeting money for strength-based resources so that we're not just thinking about children for the worst thing they ever did or the worst thing that ever happened to them, but thinking about them as where they want to go and where we want to see them. And often a challenge to that can be that we think of these as other people's children instead of our own, whatever that may mean in a culture. Because I know as a mother myself, and for the folks involved in this area, you don't think about just getting your child out of the certain circumstance that they might be in. You think about what they dream of being. And if we can bring governments into that kind of a discussion with discussions about investment and child leadership, I think we can be really successful. I want to thank you both, and thank you for putting the resources into the chat. For those of you listening, we welcome more questions, but I'm going to turn it over to somebody who is better at summarizing up these issues and thinking about the next questions we should be posing to ourselves than almost anyone I know. Professor Jennifer Davidson is with us and has been listening to the conversation. As I said, she's the Executive Director of Institute for Inspiring Children's Futures at the University of Strathclyde in Scotland, and they work internationally to reveal and resolve structural barriers to children who are in adversity. She has co-founded the Observatory of Children's Rights in Scotland and has led several international projects, including the UN Guidelines for the Alternative Care of Children. She is with us today to really think about pulling things out of really complex and very jam-packed presentations. So I will turn it over to Jennifer to give your best effort, because there's been so much here to help us pull out important lessons from today's discussion.
Thank you so much. Thanks so much to everyone for your contributions. This has been such a rich conversation for the last hour. There's been so many important points. So there's no way I can wrap up everything that I thought was important, but can I just reflect on a few things and then think about how we might take this forward and what we're seeing as movements moving forward. But while I'm speaking, really, this is to give everyone a chance to think about what's their really key, like, burning question they'd like to ask. Please, would you put those in the chat? Because this is a chance to hear from people that have really clearly done so much thinking in our global leaders in this space. So thanks, Angela, for handing over to me. So I'd like to just pull a few points together. One is, CYCJ, you've done a fantastic job of hosting this webinar and bringing the Scotland space and experience into an international space. So I want to really affirm the leadership that you've brought, because from my experience, international perspectives bring a really different lens to the work we're doing domestically. We asked a lot of questions in the session just now. How do children thrive? Angela, you've got to give us this image of a toddler wearing an extra large t-shirt, you know, that where children just don't fit in the justice systems. And Cedric, you're reminding us about the distinct approach that children need, and that this is a systemic obligation. It's not just because it's nice to do, it's actually that children are rights holders, and then these are children don't need to earn their rights. So what does that mean for us as systems leaders and those working in the system everywhere? The framework that Cedric gave us is really valuable. And I want to maybe just underline in particular, it's really fresh. It's like, this is a conceptual, we were having this webinar as the ideas are developing. It's very recently we've been talking about child-friendly justice. Only last year, the child-centered justice definition sort of has tried to shift, not just child-friendly is absolutely essential. Kindness, we heard from Zara, is really critical. But in addition to that, the systemic change that's needed is really is on the cutting edge of where are we looking for change now in our national systems. So this evolving framework we're leading up to where we're getting to around child-centered justice is really important for, I think, all of us to be thinking about in terms of relating our experiences in country to this bigger picture of how can we get to this child-centered notion. I want to also come in with an observation about the obvious that needs to always be said, which is the importance of implementation. And I think every speaker spoke to the gap between our huge ambitions for children and the norms and standards internationally, and the gap when we see how children themselves are experiencing justice in their day-to-day lives. I think it was Angela, who you spoke about multidisciplinary, multi-sector and state obligations for children's rights, this whole sort of fullness of how we need to be responding. And I thought our experience from you, Fiona, on child and from CYCJ is so inspiring, isn't it? I want to just remind us that Scotland's it was the Office of the High Commissioner for Human Rights last year who actually spoke of Scotland bringing hope and leading the way when we're seeing so much sort of falling back around the world on children's rights, or pushing back on children's rights. But I know from from just being in Scotland for some time, but also knowing from Fiona directly, who, you know, you're very humble, Fiona, but you were a pioneer in this and worked in Scottish government before you moved to leading CYCJ, and sort of, you know, wrote half the legislation that was required. You know, your hand has been in this for years, and so many committed colleagues have been working so hard. So this has been an incredible journey over many years, and it's not something that can sort of be pulled out of a hat in a year. Because, but I do want to point out a couple of things you said, Fiona, that's particularly valid and important for us to hear as sort of the drivers that I think I heard you saying in Scotland. One was the longitudinal research from the evidence from the Edinburgh study of really solid evidence and research that I think changed our perspective, because these were really well-intentioned professionals who were doing things that actually the research showed actually harmed children. They were being brought into justice systems earlier, despite the fact we thought that was a good thing. And so I think I want to emphasize the importance of having people who are stepping slightly back from the whole picture to help us see ourselves differently, and how valuable that is in the process of these things. And Zara, you mentioned coordination as being really critical in being able to shift the system. I want to say, like, I think CYCJ as a center is a great example of one of the key drivers of why this has managed to be sustained at such a high level of commitment politically for so long, is because there's an implementation center that is keeping an eye to government legislation, but also practice on the ground. And I think the inspiring piece for me in the work in Scotland is the notion of like constantly cutting edge. You know, this is a pioneering place where children and young people are saying, these are the things that are really traumatic about my justice experience. And in Scotland, we're then saying, we've got to do something about this. So we haven't even thought about alternatives to police custody, but now we have to do something about alternatives to police custody, and with a lot of hard work and advocacy that's now been brought into law. So I think it's a reminder of these steps of the framework that Cédric first introduced us to, that it takes a lot of work. There are we can be in different places on that framework at different stages, but it's a constant sort of pioneering on the edge process that needs to happen. I do want to come in also in terms of Zara, your reflections on children's participation and the importance of kindness. And I did think the way in which we're able to understand what the issues are for children is by asking them. So you gave an example of research, which I would love to see in the chat, because I've made a note for myself to follow up on that research. But I think the work in CYCJ and in Scotland has also been driven by listening first to what are children saying about their experience, and then helping that knowledge with coming to it with an open mind, to be thinking, what does that say about a system that I thought was designed in the right way? But if it's not designed to respond with kindness, or if it's not designed to address the very specific traumatic experiences children speak to us about, then we still have far to go. And so I think having our center holding on the basis of what children and young people are saying is so critical. I do want to come back also to emphasize one other thing, and before we move to some questions. People are very shy today, so please, as you're eating your lunch in front of the screen, it is time to be dropping some questions in the chat. We've got some on the side as well. So the last thing I want to bring in is this notion of Nicole. So I'm sorry, Nicole, we can't see you and your wonderful warmth in your presentation, but we could hear it in your voice. And
I'm
it's
so
a shame
sorry,
that
Jennifer. Yes, I'm sorry.
Nicole,
Tech failure today. I'm sorry.
No, our best efforts, right? But Nicole, you really framed for us some incredible quotes around. But you remind us of the governance, this being about a governance failure. Our implementation gap is about a governance failure, and the importance of needing a structural response, and that it's not enough. And this has really been the whole core of the webinar today, isn't it? It's not enough to be thinking about changing interventions. It's essential, but not sufficient. But instead, we need, and the system is not a single service. I think that was Zara that said that. So these are perspectives of a system that are so critical. But actually, it's the structural underpinnings of this that are at the core of what holds us back. And you were mentioning in Australia about the overrepresentation of children from poor households who are overly represented in youth justice. And I know that we all know that we will find that to be the case in every country. And so these are, if we're not getting to the structural components that are driving the reinforcement of these systems, we're going to continue to have the system, the phrase I think, Nicole, you said, a system paying again and again for the same failure. So thinking through how we reframe the work that we want to do together is really part of that, is thinking about how we measure these things differently. How we measure what children are telling us is most important, is the starting point, isn't it? What do children say about their experience of justice, and how do we measure these? How do we measure things differently on the basis of what they're saying? But the equation, because I do love a good simple equation, even because sometimes things are so complex, it can sort of be it can almost feel overwhelming. But the equation, Nicole, that you gave us around, we need better data to build a better business case, to then bring the politics and the political will in. And these sort of three components are, I think, important for us to hold on to as ways in which we move the dial, if you will, in various places. I wonder if we just could take a look at, there's lots of comments. If anyone would like to drop in any other messages in the chat around their reflections on what stood out for you, it would be brilliant to have that from you.
There is one question in the chat that I thought,
perfect.
Jennifer, if you or even some of our other participants, speakers want to hit, which is, I'm going to interpret it as, what does this agenda look like in 5 years? But I'm going to interpret it to mean, if we were having this exact webinar, and all of us are still in this mix of thinking about child justice systems, what's the topic of the webinar in 5 years? And I think that's because sometimes it feels like we're we're pushing sand up the same glass hill for long periods of time, especially when you're talking about implementation. And the idea that we might all be back here in 2031 saying we need to do implementation, make better business cases, and think about child leadership is a little depressing. So I wonder if folks have some creative ideas about what those differences might look like. And I want to make sure that that's also thinking about the issue of detention of children, because so much of the examples that we're talking about here have been about systems that are focused on not detaining children. So of course, a child out of detention is concerned about kindness. A child in detention perhaps is concerned about detention. So sort of where that goes, Zara, you want to jump in on that 5-year perspective?
Yeah, thank you. It just actually, my perspective is slightly pessimistic but optimistic at the same time. I think where we see the world going, I think less and less funds are going to be spent on child rights issues and more on defense or, things like, and also politically where Europe is going. It's clear that the advancements that we have seen in the last 10 years might be slowing down in some way. So I think in 5 years, we might still be at the same level. And I think we might be even happy to be at the same level and not go back on the rights. However, I also see an opening here because I'm 100% sure that certain governments, because of their certain political beliefs, are going to cut on the rights. But maybe what we could do sometimes, that's a bit instrumentalizing children's rights, but maybe what we could do is we could advocate that children are not the problematic target group, or whatever. None of them are problematic, obviously. It's just, for them to give something in return. They're going to cut on rights, but maybe just to say, okay, you have cut on so many rights, at least children are loved by everyone. Let's, promote the children's rights. This is a very kind of, I don't know, not a good way of promoting children's rights, but we have been seeing this done already in some countries like Georgia, a long time ago in Russia. So when governments become really conservative and, and start deprioritizing rights-based approaches, children still stay somewhere in the middle where we could still do something. So my hope for 5 years if we were to meet 5 years later would be at least not to go back, to keep the current level in Europe and around the world. And if we are going back, just to continue fighting anyways.
I appreciate that. And Fiona, we'll turn to you and then back to Jennifer. There's also a question in the chat, not only about 5 years from now, but one simple thing to do next. As you say, as I've learned, what's the African proverb? How do you eat an elephant? One bite at a time. What is next for how individuals who work with children every day can do something differently? Fiona.
Yep. I think, like Sarah, we don't want to go back. I think there's risks in relation to pressure maybe put on governments about what we should do. And as Jennifer said, I think even before whole systems, if we'd look at 5 years before that, we were counting and calling children persistent offenders. And we used to count them every month, and it'd be published every month in relation to 32 local authorities. And we had quite a punitive approach. And even the UK approach at the time before whole systems was, let's identify children early. And it was done, I think, with good intentions. Let's identify them early and give them all this help. And then we did look at the evidence and changed that. So it was really a significant shift, as Jennifer said. So I hope what we're doing in 5 years' time is still looking at the evidence, still listening to children and young people, acting on what they're telling us to do, and really making sure that we're evidence and sort of lived experience or voice led in all what we do. So for us in Scotland, I hope we've achieved the promise by 2030, as we've all signed up to do in Scotland, and there's still lots of outstanding recommendations from our independent care review that we need to achieve. I really hope we've got reimagining secure care, and we've got children in their local communities with multidisciplinary teams who are working for the best interests of the child. And I hope we've got our whole systems up to at least 21. Because as Cedric said, it's mid-20s before the brain is fully developed, so really up to 26 would be ideal, and that the age of criminal responsibility in Scotland is 16. That's where we're hoping, at least 16, I should say. But that's where I hope we are in 5 years' time, Angela. Maybe we should come back and see if any of that has been achieved. But that's definitely priorities for us at CYCJ.
Love that. How's that for a wish list, Jennifer?
Love it. That's great. And I don't doubt that that will progress in Scotland. And I think there's something about seeing each country in its own moment to see then what are the places that can have movement, and it may not be across all the systems at the same time, but finding the places for movement feels really important. There's a critical question, I think, here that I'd love to bring. So thanks everyone for your comments in the chat and from around the world, which is just fantastic to be hearing from colleagues from so many different contexts. I'd like to just ask briefly if anyone would like to speak to the question about the connection between children in the child welfare system and the juvenile justice system, and the what I would call the sort of assembly line, conveyor belt that sometimes happens for children in care who then come to, and I know there's been some work that's been done. Maybe Fiona, if you'd like to jump in on that.
Yeah.
Please do.
No, definitely. Yes, I think, and that was identified by our independent care review, that children who are in care are often criminalised. Things happen even in the care home that you wouldn't call the police to your own home. We do have an e-learning about rights, respect and residential care to really look at trying to change that perspective, and have been involved in training to really highlight the needs. And I think it goes back to the children in care and what are their needs, because a lot of the needs of these children, need to be addressed and not criminalised. It's about seeing them through a different lens. But we do have some resources. We've done some research ourselves, basically saying a lot of the children that we work with who have been in care have been over criminalised. We know that the research evidence is there. And it's how we address that. So it's about really looking at the staff who are working in these environments and all the external partners to try and stop that and raise their awareness about the needs of some of these children who have been placed in care, because sometimes they've been placed in really vulnerable situations. We know about ACEs, we know about trauma, and it's about looking at them through a different lens and not a criminal lens.
Thank you so much, Fiona. So I'm seeing that we're coming to the end of our time. I would like to flag that there are a few things on the horizon to be keeping an eye on. I think that there is a PowerPoint that's going to come back on. I'm looking to Angela, though she can't see, I'm looking directly at her. But I think there's a PowerPoint we're expecting to have come on that has a couple of announcements on it. And while it's coming up, I would like to just flag for everyone that the general comment of the Committee on the Rights of the Child, General Comment 27, is emerging, will be launched, we expect, in January, which will have a focus on access to justice and effective remedies. And we're listening closely for the role of judicial and non-judicial measures for children to be able to realize their full range of rights, not just children who are now in contact with justice in any way, but all children. And so I think that opens, Angela, your question about what's next in 5 years. I think this opens a really different way of understanding how do all children get ensure that they have access to their rights being realized, not necessarily through courts, but in all sorts of ranges of ways. And that gives me some sense of attention to the issues. Again, something further to be implementing. And this is something that maybe Angela, you can tell us.
Absolutely. I want to thank everybody, Zara, Nicole, Fiona, Cedric, and Jennifer, for all of your interventions and conversations. We'll just do a couple of housekeeping. What you see on the screen, if you're a US lawyer, there is a continuing legal education code for this 1.5 hour presentation on the screen. It's letter Y, letter Q, number 0, number 61726, or you can just use your phone on the screen to take a look at that QR code. And we'll show on the next slide. At Baker McKenzie, we have included this as part of our series called Talking Impact, Talking Justice. And every 6 to 7 weeks, we invite some folks in to be part of this. And we were very happy to connect with CYCJ to help to be part of this one. The next one, Baker's bringing on Understanding Disability Around the World and the launch of a Global Disability Legislation Index together with Valuable 500. So if you have interest in that arena, certainly join us on July 8th. There's also a note in the chat that Katya has shared with us about rights respecting in residential care, a presentation that you can sign up for there. And then finally, for those that are on that are interested in lawyering in this space, at our firm, we do a lot of pro bono work for the organizations that are speakers, International Center for Justice Alliance, and many more. And we have one of those opportunities in our Justice in Action pro bono sprints coming up later in the year, both in June this month and then again in October, which will include projects it's focused on child justice and child rights around the world. So we welcome you to join us. I think this may be the end of our slides and the end of our time. So with that, we'll say thanks to everyone, especially for the input and the in the meeting chat, but most importantly, to think about the fact that we'll thank you not only on behalf of all of the organizations represented, but on behalf of the young people that they serve. And that as a result of this great exchange that one of the commentators said in our chat, because we're exchanging good ideas and better practices and promising practices, we get to more reform and we get to better outcomes for young people who certainly deserve them. So thanks to everyone for all of your input today, and thank you for coming.